When you register a trademark, it's important for you to know that every trademark will not have the principal registration. What that means is trademarks have to be fanciful, unique, and different for them to be considered a registered principal mark. When they're not considered a principal mark and you are using the actual trademark, you might be able to get a supplemental mark. A supplemental mark is usually a mark that's given to a good or service that can be seen as generic, like you trying to trademark cup for cup. Here's an example of that. The USPTO actually refused the OpenAI's GPT trademark. Again, if you're a business and you're thinking about trademarking, you've been hearing about how important it is to trademark, it's still important to trademark. However, it's important for you to realize that everything is not trademarkable. OpenAI's GPT found that out the hard way. They tried to trademark GBT and it was refused. Basically, they said that the mark was refused because they said it was a feature or function of the software. GPT is actually used with a lot of things right now. So I'm not necessarily surprised because that's a feature and the function of what it does. Again, hand, and I'm trying to trademark hand, wouldn't necessarily work. So GPT, I'm guessing, is a feature and the function of what it does. Now, I'm not tech, okay? So I have no idea what the GPT actually means, but I do know it's a common used word in a lot of AI tools. So I'm guessing that's a function of what it does. Because of that, USPTO actually rejected the supplemental use as well. Think of Band-Aid for Band-Aid. Band-Aid is literally what it does. You can't trademark that name. Maybe once upon a time you can, but it's not something that you could potentially trademark now. Not just because it's a used name, but because it talks about what it does and it's so used all over that it wouldn't have the trademark protection. I'm guessing that's what they're saying with the GPT function. When you're thinking about trademarking your name, I know you've heard all over you should get a trademark, but it's the search part of the trademark is the most critical aspect of the trademark analysis. Your attorney is going to come to you and say, hey, that mark may not be trademarkable. Let's come up with something that is useful for you to use so that you are getting the best use of your money. Oftentimes, a client will come to me and they'll say, I really want this name. I'll say, do not be married to a name. Be married to the idea of you protecting your name, not necessarily the name that you have out there. The most important thing is protecting the name, not necessarily what the name is, so that you can get the brand protection that you need. If you don't have the protection because it's already used or it's too generic of a name, you don't want to waste your money and your time.